Somewhere right now, there is a family that has been waiting for over 20 years. A brother in Manila who was petitioned by his sister the year the iPhone didn't exist yet. A married daughter in Mexico City who has watched her children grow up, finish school, and start their own families, all while a single piece of paper sits in a government file somewhere, slowly moving through a line that never seems to end. If you filed an F3 or F4 petition, or if you're the beneficiary of one, and you opened the March 2026 Visa Bulletin hoping to finally see some movement, only to feel that familiar sinking feeling in your chest, this video is for you. Because today, we are going to explain exactly why your petition is still stuck, what the numbers actually mean, and what you can do right now to make sure you don't lose your place in line after waiting this long. Don't go anywhere. The detail we cover at the 10-minute mark is the one most families miss completely, and it could cost them everything they've waited for. This channel exists for one reason. When executive orders drop, when visa bulletins come out, and when rumors start spreading through family group chats and immigration forums, we come here and we look at the official text. Not the speculation, not the panic posts, the actual documents, the actual data. While social media is full of noise, we are looking at what the State Department actually published, what USCIS actually says, and what the law actually requires. And as always, I want to be clear from the start. I am an analyst helping you understand the system. This is educational content, not legal advice. Your case has specific details that only a qualified immigration attorney can properly evaluate. Please consult one, especially before making any filing decisions. Now, let's get into it. The F3 and F4 categories are part of what's called the Family-Sponsored Preference System. These are not immediate relative categories. Immediate relatives, meaning spouses, unmarried minor children, and parents of U.S. citizens, have unlimited visas available to them. They don't wait in a preference line, but everyone else does, and F3 and F4 are at the very end of that line. F3 covers married sons and daughters of U.S. citizens. F4 covers brothers and sisters of U.S. citizens. Both of these categories are capped. Congress allocates a fixed number of immigrant visas to these categories every single fiscal year, and that number has not kept pace with demand for decades. Here is the core of the problem, and this is important, so stay with me. Each country, regardless of its population, regardless of how many people from that country have been petitioned, is limited to no more than 7% of the total annual family preference visa numbers. 7%. That sounds like it could be reasonable until you realize that countries like Mexico, the Philippines, India, and China have filing volumes that dwarf the rest of the world combined. So those 7% caps hit those countries almost immediately, and everyone else from those countries gets pushed further and further back. What does that mean in real numbers? In the March 2026 Visa Bulletin, the F4 category for the Philippines has a priority date cutoff that is sitting in the early 2000s. We are processing petitions that were filed over 2 decades ago. For Mexico, the F3 and F4 cutoffs tell a similarly painful story, with waits that stretch well beyond 15 to 20 years for many applicants. And these dates are not moving quickly. In some recent bulletins, they have barely moved at all. Some months, the cutoff date for a heavily backlogged country moves forward by just a few weeks. A few weeks of progress after an entire month of waiting. But this is where it gets complicated, and this is the part most people don't fully understand. The Visa Bulletin has 2 charts, the Final Action Dates chart and the Dates for Filing chart. The final action date is the one that actually matters for completing your immigration process. Your priority date, which is the date your I-130 petition was originally filed, must be earlier than the final action date before USCIS or a consulate can approve your immigrant visa or adjust your status. The Dates for Filing chart, when authorized for use, just means you might be able to submit paperwork early. It does not mean your visa is available. These 2 charts cause enormous confusion, and every time a Dates for Filing chart shows a more recent date, forums fill up with people thinking they've finally reached the finish line when they haven't. For March 2026, there is essentially no meaningful forward movement in the F3 and F4 categories for the high-demand countries. The State Department's demand projections, combined with the annual numerical limits, have created a situation where even in a best-case scenario, movement is measured in weeks per month, not months per month. Let's look at the facts. not the fear. There is a rumor that has been circulating in some communities that new legislation is about to eliminate these visa categories entirely. That is not accurate as of now. These categories exist in statute. Eliminating them would require an act of Congress, and while immigration legislation is always in motion, there is no enacted law as of the time this script was written that eliminates F3 or F4. What is true is that there have been ongoing policy discussions and various legislative proposals over the years, some of which would reshape the family preference system. But proposals are not law. If something changes, we will cover it immediately on this channel. For now, your petition is not canceled. Your place in line has not been taken away. What you are experiencing is the reality of an overwhelmed numerical system, not a policy that has specifically targeted you. Now let's make this real for a moment. Think about a woman named Rosa. She came to the United States, became a citizen after years of effort, and in 2004, she filed an I-130 petition for her brother in the Philippines. She did everything right. She filed early, she paid the fees, she got the receipt notice. Her brother was young then, in his late 20s, unmarried. Today he is in his late 40s. He is married. He has children who were born and grew up during the time this petition has been pending. His original petition is still valid. His priority date is still protected. But every month he opens the Visa Bulletin and sees a cutoff date that is still years away from reaching him. Rosa calls her brother on his birthday, and they talk about what life will look like when he finally arrives. They've been having that same conversation for 2 decades. This is not a hypothetical. This is the daily reality for hundreds of thousands of families in this system. And understanding why it happens doesn't make the pain smaller, but it does help you protect yourself from making mistakes that could make the wait even longer. Stay with me, because the next point directly affects your timeline and your ability to actually use your visa when your date finally becomes current. One of the most damaging things that happens to families in the F3 and F4 backlog is a completely preventable administrative problem. People move. Life happens. You filed that I-130 petition 15 years ago, and since then you've moved 3 times. Your petitioner retired, maybe changed phone numbers. And somewhere in the process, the National Visa Center, which is the agency that manages the case between USCIS approval and the consular interview, has an old address, an old email, a disconnected phone number. When your priority date gets close to becoming current, the NVC will attempt to contact you or your petitioner to begin collecting documents, fees, and scheduling the interview. If they can't reach you, your case goes into a kind of administrative hold. You don't get notified because they can't find you, and cases can sit there for years before families realize what happened. By the time some families figure it out, additional processing delays have compounded the problem. This is the step most applicants miss completely. Keep your contact information updated with the NVC. You can do this through the CEAC portal, which is the Consular Electronic Application Center at ceac.state.gov. The petitioner, meaning the U.S. citizen who filed the original I-130, is responsible for making sure the NVC can reach them. If the petitioner has passed away, that is a separate and more complex situation that absolutely requires an attorney, because the rules around humanitarian reinstatement are specific and time-sensitive. So here are 3 concrete steps you can take right now. First, confirm your priority date and your place in line. Find your original I-130 receipt notice. The date on that notice is your priority date. Then, go to travel.state.gov and read the current Visa Bulletin for your category and your country of chargeability. Compare your priority date to the final action date listed. If your date is earlier than the cutoff, that is a signal that you may be getting close to entering the active processing phase. If it's not, you now know roughly how much runway remains. Second, update your contact information with the NVC immediately. Don't wait until your date is current. Go to cac.state.gov and make sure the NVC has a valid email address, a current phone number, and a correct mailing address for both the petitioner and the beneficiary. This is free. It takes minutes, and it could prevent a devastating delay. Third, if your priority date is within the next 2 to 3 years of becoming current, schedule a consultation with an immigration attorney now, not later. Not when the date is current, not when the NVC sends a letter. Now. An attorney can review whether anything has changed in your situation, whether your beneficiary's circumstances, such as a marriage, a divorce, aging out of a derivative status, or a criminal matter, could affect eligibility. Waiting until the last minute in a system this complex is how families lose cases they've waited 20 years to see resolved. The F3 and F4 backlog is one of the most painful and least understood parts of the U.S. immigration system. It is not broken because people did anything wrong. It is backed up because the demand has always far outpaced the numerical limits, and because Congress has not meaningfully reformed the family preference visa system in decades. The families waiting in this line did not create the problem. They are simply living inside it. What you can control is whether your case is protected, whether your contact information is current, and whether you are informed when things change. Because immigration policies shift quickly. A new Visa Bulletin drops every single month. Executive actions can redirect resources toward or away from consular processing. Priority date cutoffs can move forward or retrogress. And the only way to stay ahead of any of it is to stay informed. If this video helped you understand your situation even a little bit more clearly, hit that subscribe button right now. Not for us, for you, for your family, for the brother in Manila and the daughter in Mexico City, and every family in between who has waited long enough to deserve to know exactly where they stand. Subscribe so that the next time a Visa Bulletin drops, the next time a policy shifts, the next time a rumor starts spreading through your community, you already have the clear and accurate answer waiting for you here. Your wait has been long enough. Don't let a lack of information be the thing that makes it longer.